There we go. So the Supreme Court is also known as the guardian of the Constitution. So the judicial branch is also known as the Supreme Court, and their nickname is they are the guardian of the Constitution. The power of the Supreme Court is described in Article 3 of the Constitution. Again, the power of the judicial branch is described in Article 3 of the Constitution. And the most important thing that the Supreme Court does is it provides judicial review. So that's gonna be our next slide. We're gonna look at what is judicial review. So in judicial review, laws and actions from Congress and the president. So these laws and actions from Congress and the president are reviewed by the Supreme Court. Slideshow is just the judicial review or the judicial branch. So again, in judicial review, the laws and actions from the Congress and the president are reviewed by the Supreme Court. So they're reviewed by the Supreme Court to determine if they are constitutional. The concept of judicial review is officially set up in Marbury versus Madison in 1803. So again, judicial review is started under Marbury versus Madison from 1803. And John Marshall is the head of the Supreme Court, is the Chief Justice. So John Marshall is the Chief Justice of the Supreme Court. He is the one that writes about judicial review in Marbury versus Madison. Sorry, I'll say that one more time. I'll say that again. So John Marshall is the Chief Court Justice of the Supreme Court. And he's the one that writes the Supreme Court opinion that establishes judicial review. Any questions on this concept of judicial review? Or what it is? Yes, Kina? John Marshall wrote the Supreme Court opinion for Marbury versus Madison, which sets up judicial review. So John Marshall is the one that officially speaks into what judicial review is. Now, where do the courts and jurisdictions come from? So who's in charge of these court cases? Okay. So Article 3 creates one Supreme Court and such inferior courts. So the Supreme Court is obviously Supreme Court of the United States. And these inferior courts are just courts underneath the Supreme Court, which we'll cover in the next slide. So Congress creates the system underneath the Supreme Court, which means that Congress is giving these lower courts the resources that they need to function. Now, there are a bunch of different courts, which I'm going to show you guys in the next slide, just so you guys know the best way to organize the next slide is probably going to be like a T-chart. So there are two types of courts at the federal level. We have constitutional courts and special courts. I'll give you guys 1 minute if you guys want to copy down the big ones. So constitutional courts are the U.S. Supreme Court, Court of Appeals, district courts, and the U.S. Court of International Trade. In the special courts just focus on one specific issue. So we have the Court of Federal Claims, military tribunals, Court of Appeals for the Armed Services, territorial courts, U.S. Tax Court, Court of Veteran Affairs. I would just write like a couple examples. So like for the special courts, if you guys know that like the U.S. Tax Court and the Court of Veteran Affairs are special courts, that's enough. The clear distinction between the constitutional courts and the special courts is the special courts hear cases related to the powers of Congress. So again, special courts hear a smaller amount of cases that are directly related to the power of Congress. So for example, since Congress is in charge of the military, determining where the funds for the military go, that is why if you are at a military tribunal or if you're a veteran arguing for your benefits or something that like that, that's why you would go through a special court instead of a constitutional court. Does that make sense? Court of Federal Claims, military tribunals. And you don't have to write all those down if you just have a couple examples. Okay, that back corner, wake up for me, please. So the constitutional courts are specifically about like issues of if a law or a policy is constitutional. And the nickname for these three courts here, the Court of Appeals, the District Courts, or the U.S. Court of International Trade, these three are called inferior courts. Because you have the Supreme Court and then you have the inferior courts underneath it. So like these three right here are also known as inferior courts. If you can just like write like a dash next to it, as long as you know that like anything underneath the Supreme Court here is an inferior court, you're fine. These three. Court of Appeals, District Courts, and U.S. Court of International Trade, these three are called inferior courts. An inferior court is a constitutional court that is not the Supreme Court. So let's say you feel as if your rights are being violated and you need to argue that a law or something that is affecting you is unconstitutional. How do you do that? There are 3 steps. Step number 1, you would go to a district court. If you go to the district court, you argue your case and the court rules in favor of you, that's it, you're done, you go home. But if the district court rules in a way that you don't agree with, you would take it to the Court of Appeals. Now, if the Court of Appeals agrees with you, great, you're done, you go home. But let's say the Court of Appeals continues to not rule in a way that you agree with. You would then petition the Supreme Court and ask for them to see your case and see if they do. Okay, now here's just a bit of additional information. There are 91 district courts, 12 Court of Appeals, but only 1 Supreme Court. We have 9 Supreme Court judges. If you go to the Court of Appeals, you would talk before 3 different judges, but if you go to a district court, it's just 1. Any questions on how a Supreme Court case or how a court case gets to the Supreme Court? Huh? Yeah. You guys want to get your notes set up? The next slide is talking about federal courts. Federal courts. Good. All right. So what are the principles of the court? So like, and by principles, I mean like, what are the values that these courts are supposed to follow? 1, we treat all people equally. Again, these are what they're supposed to follow. And we also believe that everybody is innocent until proven guilty. Now, obviously, this is easier said than done. So there are some difficulties with this. One, what kind of personal prejudice might you have? So some Supreme Court justices are still human, and they all have their own biases and their own prejudices, either towards groups of people or just the Constitution itself. And it is far harder for a poor person to have their issues heard than a rich person, for obvious reasons. Rich people have a much higher volume of resources in order to be able to argue their own court case or get their court case seen. Oh, I'm so sorry. Now, there are 4 types of jurisdiction, which means who hears what kind of court case. If something falls under exclusive jurisdiction, that means that only a federal court has the authority to hear the case. So again, if something is exclusive, only the federal court has the authority to hear the case. Concurrent jurisdiction means either the state or federal court can hear the case. If it's under original jurisdiction, that means that only the first court to get the case can hear it. And the last type of jurisdiction is appellate. Which means that the court can only hear a case on appeal. Concurrent? A concurrent means that either a federal or state court can hear the case. We're going to keep going with the jurisdiction slide. So, U.S. district courts have original jurisdiction. Which means that these U.S. district courts can hear the case first. The Court of Appeals obviously has appellate jurisdiction. And finally, the Supreme Court has both of these types of jurisdictions. So what this means is if, let's say you have a court case, your right to freedom of speech has been violated in a way that you think is very unique and in a way that is like, should be heard by the Supreme Court, you can appeal to the Supreme Court directly. Or if you hear a Supreme Court case, I mean, if you go to a court, they don't agree with what you do, you can appeal the decision up to the Supreme Court. Okay. So how do you become a judge of the Supreme Court? As we've discussed, the president appoints and then the Senate approves. But something to note is nowhere in the Constitution does it say what qualifications a Supreme Court judge needs to make. So there are no technical qualifications. So like, for example, the president has to be at least 35 years old. There's nothing like that written for a Supreme Court judge. They're picked by the current president. And then something extremely unique to the Supreme Court that we do not see for any other branch of government is that they are appointed for life on good behavior. So judges are not elected. Once you become a Supreme Court judge, as long as you're not a terrible person, you're going to be a Supreme Court judge for as long as you want. Now, the reason why judges are appointed for life instead of elected is because if you are elected as a judge, you're going to be more susceptible to voting for certain cases based off of what you think will keep you elected, right? Whereas if you're just securely in the Supreme Court and you don't have to worry about being replaced, you're going to feel it's supposed to give you more freedom and more authenticity to the Constitution. Does that make sense? Now, a Supreme Court judge may be impeached. So again, you're a Supreme Court judge for life, but if you do something illegal, you're going to get removed from the Supreme Court. Galaxies. Oh, I'm so sorry. You guys are setting up your notes. The next slide is going to be on the Supreme Court. So now the Supreme Court, as I said, if you have a very unique case, you can appeal to the Supreme Court directly, but ultimately it is supposed to be the court of last resort, which means that you've used all of your resources, but it doesn't matter. It is just not going in the right direction. the Supreme Court, and then the Supreme Court will use its process of judicial review to determine if it is constitutional or not. Now, to get a little bit more technical, how does a case reach the Supreme Court? So let's say you've appealed your court case. How do the Supreme Court judges choose to hear it? Technically, it is called a writ of certiorari. Don't know how to speak Latin. Which stands for a rule of 4, which means if 4 Supreme Court justices want to hear the case, it will go before the court entirely. So again, if 4 justices at the Supreme Court want to hear your case, debate it, and then rule on it, it will go up to the Supreme Court. Now, if a lower court cannot make a decision on which direction to go, the Supreme Court can also issue a certificate. So if a lower court or an inferior court is super deadlocked and they go up to the Supreme Court and say, we cannot make a decision, the Supreme Court will issue them a certificate to bring the court case up to them. Now, for those of you guys that have seen it's a trial process at the Supreme Court. It's about 5 more slides like this, you guys. We've only been doing this for about 20 minutes. It's all on the slide. This is what you guys ask me for all the time. Okay. All right. So for those of you guys that have watched a lot of Law and Order like I have, a court case at the Supreme Court looks nothing like that. There's no evidence or witnesses. So you don't go before the Supreme Court judges and like swear on the Bible and do all that stuff. Because again, you're not being tried for a crime or anything like that. A issue in terms of a law being constitutional or something like that is what is being tried. So there's no evidence, and there are no witnesses. So there's no evidence, no witnesses. Instead, the attorney for each side will present their arguments for 30 minutes while being questioned by the judges. Yeah, so the attorney presents their arguments for 30 minutes, and then the judges will ask them questions about their argument. So it honestly looks a little bit more like a debate. Okay. Now, once those arguments are over, justices write those opinions. So when we went over Marbury versus Madison, McCulloch versus Maryland, and I think it was US versus Lopez, when we were talking about the Supreme Court cases, we were reading those opinions. So once arguments are over, justices are going to write opinions, and then each justice chooses which opinion to sign. Now, the majority opinion is obviously the one signed by the majority of the court, of the Supreme Court justices. And what's important about the majority opinion is it sets a precedent. So a precedent is an important decision that future court cases will follow. So for example, Plessy versus Ferguson, the Supreme Court case that says that separate but equal segregation is constitutional. So that court case that decided that segregation was constitutional, that precedent had to be overturned in Brown versus Board. So until Brown versus Board, Supreme Court justices agreed with the precedent set by Plessy versus Ferguson. Does that make sense? Yeah, so precedent just means that is the court's opinion that they will follow in related future court cases. So if for some reason in the year of 2022, we have a court case about segregation or something like that, those court judges would refer to the precedent set by Brown versus Board. Does that help? Now, and on the other side, we have the dissenting opinion. The dissenting opinion is obviously by the minority amount of the judges. They disagree with the decision that the court is making, and they argue for why. And a concurrent opinion is just basically like the opinion agreeing with the majority opinion, but they want to add in their own information. So like in discourse where when you guys say, I agree and I would like to add, that is basically a concurrent opinion. Okay. Now going off of Kayla's question, great setup. We're going to talk a little bit more about what precedent is. There are only 2 more slides that you guys need to take notes on. This one and the next one. Only 2 more slides. Okay. So as I just said, Plessy versus Ferguson and Brown versus Board is a good example of what precedent is. To stamp what I just told Kayla, precedent, the precedent set by a court case is basically a guideline for all following court cases. And as I said earlier, Plessy versus Ferguson sets the precedent that it sets the precedent that segregation is legal. That's what Plessy versus Ferguson says. Segregation is constitutional. But then over 50 years of history happens, things change, people change, and Brown versus Board argues another issue of segregation. And this new Supreme Court says, actually, segregation is not constitutional, and they change that precedent. Going alongside that is what we call stare decisis or stare decisis. And stare decisis is a legal doctrine that obligates courts to follow historical cases. So again, stare decisis is a legal doctrine that obligates courts to follow historical cases. Last slide you guys need to take notes on. These are just a few names that are good for you guys to know. John Jay is the very first ever Supreme Court Justice. You might recognize his name. He's one of the 3 authors of the Federalist Papers. Thurgood Marshall is the first African-American Supreme Court Justice. And Sandra Day O'Connor is the first female Supreme Court Justice. These are just people that might be referenced in future Supreme Court cases. Yeah, Thurgood. Thurgood. So yeah, we have John Jay, first one ever. Thurgood Marshall, first Black one. And Sandra Day O'Connor is the first female. Okay. We don't have to write these down. I'm just going to go over it. We're not writing this down. You guys are not writing the next 2 slides. So this is the current Supreme Court. The current Supreme Court minus, no, this is replaced with Amy Coney Barrett. So this is what the current Supreme Court looks like. This changed very recently, just last year, when Ruth Bader Ginsburg sadly passed away, and we got replaced with Amy Coney Barrett. Amy Coney Barrett. So like you guys might have seen this in the news at any point last year. She was the one that was very, I think she became a TikTok noise because she couldn't name the 5 freedoms listed in the First Amendment. Yes, this is our Supreme Court Justice. So if you guys can name the 5 freedoms of the First Amendment, which are speech, religion, petition, assembly, and religion. Huh? Yeah, so the 5 freedoms are religion, press, speech, petition, and assembly. She could not name petition. So if you guys heard that TikTok noise of somebody going and put like where they couldn't do it, that's her. A lot of people were upset with her nomination to the Supreme Court because she was nominated very, very, very close to an election year. She was nominated and approved. So a lot of Democrats thought that her appointment was unfair because we were in the middle of an election cycle. And so we didn't know if Trump was going to continue to be president. So this is one of those wiggle rooms where the Supreme Court is a very, very difficult place to be. So go ahead and we are not going to do the documents because we just don't have time. So I want us to just check your notes, make sure you could answer these 2 questions with your notes. And I want us to talk about the exit ticket very quickly, just so that way I can make sure that we are all on the same page about what the exit ticket is asking.